I'm joined now by our legal advisor. He is here to shed some more light on the charges against David Johnson. Paul Daranassian is a partner at the Albany-based law firm Daranassian and Daranassian. Paul, thank you very much for your time tonight.
Good to see you, Liz.
So the charges against David Johnson, what you know of them here, are they fair, and does it appear to you that any special treatment was given to him, or this is a fairly standard situation?
I think the charges are typical of what you'd see in this type of case, in a domestic violence case, the harassment, which is a violation, the menacing, the assault charge. That's exactly what you'd see. If there's something unusual, is that it took so long to get here. And I think that was because of the allegations involving the governor and interference. And I think the DA said he wanted to wait until Judge Kaye was finished with her report.
Now, this is actually indicative of how difficult it is to prosecute domestic violence cases. It's a very big problem because frequently you have one person's word against another.
This is classic in many ways, and I think if you look at Hiram Montserrat's case, many of the same issues you see over and over again. The attitude of victims is important, but you see in this case the efforts to pressure someone to not come forward and testify, the conflicting loyalties. And I think that's what makes these cases difficult. You see it in this case, and what happened here with the governor and his aides is no different from what happens in many other everyday cases.
Except usually it's now the governor of the state of New York, who ostensibly is the most powerful person in the state. I mean, to be a victim and get that kind of call, I mean, it has to be a significant thing. I mean, you're dealing with a significant amount of power from someone who could really influence you.
Absolutely. It's the implied force and threat that goes with the position, and that's what makes it so difficult. And as I said, unfortunately, many victims have to deal with this in a variety of contexts in the area of domestic violence.
Let's go back to the Hiram Montserrat case for a second. In that particular case, the former senator, he was expelled actually by his colleagues after his conviction on a misdemeanor charge, but what he was charged with initially was a felony. And that's because he actually used this piece of glass, and in this case there was no glass, so we're starting with a misdemeanor?
That's right, Liz. I think, using a dangerous instrument or object can make it a felony. Now, sometimes there's some element of discretion that a prosecutor has. For example, a wall or floor can be a dangerous object, but that is the fundamental difference here. But it's also an important difference in terms of how this case may eventually resolve.
And what does that mean? In other words, when you start with a felony, you have room to plead down. When you start with a misdemeanor, you have room to plead down to something that's actually really not so significant.
The felony charges in Montserrat made it much more difficult to allow a plea to a misdemeanor. In this case, by starting with a misdemeanor, the prosecutor can more easily allow either a plea to a misdemeanor with no jail time, maybe reduce it one level to an attempted assault. And I think it gives a greater opportunity to resolve the case because the stakes aren't as high.
What do you think, I mean, game out what you think might happen from here. I mean, is it likely that they will settle out of court? We're seeing that supposedly they're going to be back in court in October, which of course is good for no one, right? It's difficult for the victim if she has to testify and relive the experience. Difficult, obviously, from an optics standpoint for the governor. And of course, the person who is the alleged assailant doesn't really want this whole thing aired in court either.
Well, I think you're pointing out that sometimes non-legal factors affect legal outcomes, and you're exactly right. So, for example, October wouldn't be a great time to air anything. Wait until after Election Day. And probably, if you're the defendant in this case, do you really want to expose everything that happened? Do you want a public trial of all the efforts you made to stop this person from coming forward? Probably not. So I think it's most likely that you'll see some sort of resolution here, some form of probation eventually, but again, after Election Day.
And more, even though the governor is not actually standing for election, I mean, you're talking about a time where the last thing that you want for Democrats, and you're a Democrat and you've also been in the political system, the last thing you want is anything, particularly amid such a cloud for Democrats of Charlie Rangel and in Washington at any rate, Maxine Waters and other issues in terms of scandal upon scandal in Albany, clouding up the waters more when you're headed into an election season.
I think that's part of it, but also, do we like to see our chief executives undergo that type of public display and humiliation? If you think of Nixon, if you think of Clinton, there was tremendous pressure on the system to not expose it and not put the country through something. I think here, too, do you think the prosecutor, do you think the system wants to put our chief executive through this? Not if it's not absolutely necessary.
Were you surprised by the outcome of the Kaye report?
I was a little surprised because I thought the conduct involved here was pretty strong conduct in trying to get someone to not testify. And again, what lawyers will often say, though, when in doubt, when we don't want to call something a crime, is say error in judgment. And to say it was an error in judgment is certainly very kind.
That is an interesting assessment. Of course, we should also say the governor's not out of the woods yet. He still has the Public Integrity Commission to deal with, and he has this Yankees tickets issue that's hanging out there that the former chief judge has not yet weighed in on. I want to thank you very much for joining us. I'm sure you'll be back to talk to us again.
My pleasure.